Hello everyone and welcome to the February 2026 edition of MAIPF Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case law update is the unpublished opinion per curiam of the Court of Appeals that was issued on January 15, 2026 of Neal J. Campbell versus State Farm Mutual Automobile Insurance Company, Auto Club Insurance Association, and the MAIPF. The second case we will discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on January 22, 2026 of Nader Kourani versus American Select Insurance Company. Lastly, we will focus our discussion on the trending topic of PIP litigation pertaining to independent contractors versus employees under the Michigan No-Fault Act, specifically under MCL 500.3114 subsection 3. For this, I will give a brief overview of the topic. There's also a related recent unpublished opinion per curiam of the Court of Appeals involving several consolidated suits involving an underlying claimant named Caden Knight, titled University of Michigan Regents versus State Farm Mutual Automobile Insurance Company, Auto Owners Insurance Company, Homeowners Insurance Company, Geico General Insurance Company, Geico Indemnity Company, Government Employees Insurance Company, and the MACP and MAIPF will be discussed. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on January 15, 2026 of Neal J. Campbell versus State Farm Mutual Automobile Insurance Company, Auto Club Insurance Association, and the MAIPF. This case discusses when a motorcyclist is injured by a motor vehicle whose policy includes a qualified health coverage exclusion under MCL 500.3109A subsection 2. The central question of the case is whether the exclusion removes the motor vehicle insurer from priority, or must that insurer still pay benefits when the injured motorcyclist is not among the excluded individuals. In this case, plaintiff Campbell was catastrophically injured on April 26, 2023 while operating a motorcycle when struck by a car driven by Vanessa Boswell. Plaintiff's injuries included below-the-knee amputation, pelvic injuries, and thoracic spine injury causing paralysis. Boswell's vehicle was insured through Defendant Auto Club, and she selected $250,000 PIP coverage with a qualified health coverage exclusion. Plaintiff had a State Farm automobile policy with unlimited PIP coverage and motorcycle insurance. State Farm denied allowable expense benefits, claiming that plaintiff was limited to benefits under the striking vehicle's coverage and possibly through the Michigan Assigned Claims Plan. Plaintiff filed suit seeking a determination of which insurer owed him PIP benefits. At the trial court level, all parties filed competing motions for summary disposition. The trial court ruled Auto Club's policy exclusion, removed it from priority, ruled State Farm was responsible for PIP benefits, awarded attorney's fees and penalty interest due to delay, dismissed the MAIPF, and ruled that a consent judgment required State Farm to pay benefits but preserved its right to appeal. State Farm appealed the priority ruling. And again, State Farm is the insurer of plaintiff Campbell, who had the automobile policy with unlimited PIP coverage and motorcycle insurance. Under MCL 500.3114 subsection 5, when a motorcyclist is injured by a motor vehicle, priority generally follows the insurer of the motor vehicle owner/registrant, then the insurer of the motor vehicle operator, then the insurer of the motorcycle operator, and then lastly, the insurer of the motorcycle owner. MCL 500.3114 subsection 6 allows skipping a policy if the insured opted out under section 3107D or a 3109A subsection 2 exclusion applies. The Court of Appeals relied heavily on the case of Love versus Randolph, which held that the section 3109A subsection 2 exclusion applies only to the named insured, spouse, or resident relatives. A third-party motorcyclist is not excluded. Therefore, the insurer remains in priority. Because plaintiff was not within the excluded class, the court found that Auto Club's policy was still applicable and was the highest priority insurer, and thus responsible for PIP benefits. The case was remanded for entry of judgment in favor of State Farm. Judge Wallace wrote a concurring opinion arguing, 1, that the statute's plain language suggests policies with Section 3109A subsection 2 exclusions should be skipped entirely. And 2, the Love versus Randolph decision was wrongfully decided, and the Michigan Supreme Court should reconsider the interpretation. The second case we will discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on January 22nd, 2026, of Nader Kourani versus American Select Insurance Company. This case centers on assignment of rights and the real party and interest requirement in Michigan no-fault litigation. The key issue is whether an insured may pursue reimbursement for medical expenses after assigning those rights to a healthcare provider, and whether an insurer may rely on those assignments to defeat the claim. Plaintiff Kourani was injured in a motor vehicle accident on September 12, 2021. Plaintiff received treatment at Northland Radiology from March 2022 through June 2023. Each visit included execution of an assignment of rights, transferring plaintiff's right to recover no-fault benefits to the provider. Plaintiff was insured by American Select Insurance Company. Plaintiff filed suit in 2022 against American Select, seeking uninsured/underinsured motorist benefits, and later added a claim for first-party no-fault benefits. American Select moved for summary disposition, arguing plaintiff was not the real party in interest. American Select argued that, due to the assignments, Northland Radiology, not the plaintiff, was the proper party to pursue payment. A representative from Northland Radiology testified that the clinic required assignments after the Michigan Supreme Court's decision in Covenant Medical Center, Inc. versus State Farm Mutual Automobile Insurance Company, and continued using them even after statutory amendments allowed direct provider claims, but did not intend to enforce the assignments. Trial court ended up holding that 1, the assignments were valid and enforceable, 2, the provider's affidavit did not revoke them, and 3, claims for services before November 13, 2022 were barred by the 1-year back rule. Leave to appeal was denied earlier, case was later dismissed pursuant to stipulation, and the plaintiff later appealed as of right. Now, in discussing the real party and interest requirement, under MCR 2.201 subsection B1, actions must be brought by the real party in interest, the entity holding the legal right to recovery. The Court of Appeals emphasized a plaintiff who assigns a claim generally loses the right to sue on that claim, and failure to bring suit in the name of the real party in interest is grounds for dismissal. The court relied on the Michigan Supreme Court's decision in C-Spine Orthopedics PLLC versus Progressive Michigan Insurance Company, which reaffirmed that assignments transfer the right to recover benefits, plaintiffs cannot pursue assigned claims unless the defect is properly cured, and rescission is equitable and must be judicially approved. Plaintiff did not revoke or rescind the assignments in the present case. Plaintiff further argued the insurer could not enforce the assignments because it was not a party to them. The court rejected this argument as the insurer was not challenging the validity of the assignment. Instead, it relied on the assignment to show plaintiff was not the real party in interest. Because assignments determine who holds the claim, the insurer may raise the issue. With respect to the validity and enforceability of the assignments, the court held that contracts are presumed valid and enforceable. The assignments were unambiguous. Plaintiff provided no traditional contract defense like fraud, duress, illegality, etc., and the provider's claim it did not intend to enforce the assignments did not invalidate the agreements. Lastly, with respect to the 1-year back issue, plaintiff argued enforcement could leave him liable for medical bills. The court found any provider claim would be subject to the No-Fault Act and the 1-year back rule. Any potential claim against plaintiff had expired, and plaintiff faced no unjust enrichment. Overall, the Court of Appeals affirmed the trial court's ruling, held the assignment was valid and enforceable, determined plaintiff was not the real party in interest for the assigned claims, and concluded that dismissal of those claims was proper. I want to now focus our discussion on the trending topic of PIP litigation pertaining to independent contractors versus employees under Michigan No-Fault Act, specifically under MCL 500.3114 subsection 3. The premise of this section of the statute is that it determines which insurer must pay PIP benefits when an employee is injured in a motor vehicle accident involving an employee's vehicle. The key is that an employee injured while occupying a motor vehicle owned or registered by the employer must seek PIP benefits from the insurer of the employer's vehicle rather than from their own or a household policy. This priority rule applies if the injured person is an employee, not an independent contractor. The injury arises from a motor vehicle accident. The employee was occupying, i.e. driving, riding in, entering, or exiting a vehicle, and the vehicle is owned or registered by the employer. The effect of MCL 500.3114 subsection 3 is that it overrides the general rule that a person first looks to their own or household insurer. It further places financial responsibility on the employer's auto insurer when injuries arise from work-related vehicle use. It prevents shifting work-related auto injury costs into personal insurers. Important considerations include determining employee versus independent contractor status. Here, courts often apply what we call the economic reality test to make that determination, and that the provision is intended to align risk with commercial vehicle use. There is a related recent unpublished opinion per curiam of the Court of Appeals involving several consolidated suits involving an underlying claimant named Caden Knight, titled University of Michigan Regents versus State Farm Mutual Automobile Insurance Company, Auto Owners Insurance Company, Homeowners Insurance Company, Geico General Insurance Company, Geico Indemnity Company, Government Employees Insurance Company, and the MACP and MAIPF. This case centers on the proper classification of a worker as an employee versus an independent contractor under the Michigan No-Fault Act and how that classification affects priority for payment of PIP benefits. Here, the Court of Appeals examined the economic reality test and statutory priority rules to determine which insurer was responsible for coverage. The facts of this case were that the underlying claimant, Knight, performed various tasks for a company called Bear Affair, a family-run business operated by his grandmother. Knight was paid hourly in cash or through purchases made for him, kept informal records of hours, and had no written contract or tax documentation. While driving a Bear Affair-owned 2019 Ford Transit back to Michigan from a gymnastics meet, Knight ran out of gas in Pennsylvania. After pulling off the road and exiting the vehicle, he suffered serious injuries and was hospitalized for approximately 3 months. He later received extensive treatment, including ligament repair surgery and physical therapy. Knight sought PIP benefits. The company vehicle was insured by auto owners. Household relatives with whom he lived had vehicles insured by Geico and State Farm. Thus, all these insurers were brought into the suit. Knight filed suit in Wayne County seeking PIP benefits from multiple insurers. The University of Michigan Health System filed a related action in Washtenaw County to recover medical costs. The Washtenaw County trial court in that case granted summary disposition to auto owners, ruling Knight was an independent contractor and not entitled to coverage through the company vehicle policy. In the Wayne County trial court case, the underlying PIP suit, they reached the opposite conclusion, finding Knight as an employee and placing auto owners first in priority for PIP benefits. Appeals were filed by Geico, State Farm, and auto owners, resulting in consolidated appellate review here. The Court of Appeals, of course, first looked to MCL 500.3114 subsection 3 here. To determine employee status, the court further applied the economic reality test, including factors from Adenaulic versus Harco National Insurance Company, citing the case of Parham versus Preferred Risk Mutual Insurance Company, and that is the 4-factor test, and also in McKissick versus Bodine, the 8-factor test. The court reiterated that no single factor is controlling and that courts assert the totality of circumstances when figuring out the economic reality test. Here in this case, the factors supporting employee status included Knight could not be terminated at will with no legal recourse. He used company vehicles and sold company products. He did not hold himself out as an independent contractor. His work selling merchandise was integral to Bear Affair's business, and the statutory objective favors assigning risk to the business insurer when injuries arise from the use of business vehicles. The neutral/mixed factors considered by the court included informal payment methods and lack of tax documentation, limited supervision and flexible scheduling, unclear reliance on income for living expenses. And finally, the irrelevant / non-determinative factors the court indicated were familial relationship between Knight and the business owner and lack of formal employment documentation. The court emphasized that the relevant inquiry is whether the type of work performed is integral to the business, not whether the individual worker is indispensable to the company. Ultimately, the Court of Appeals held that Knight was an employee of Bearer Fair under the economic reality test, and the employer's vehicle insurer auto owners is first in priority for PIP benefits under MCL 500.3114 subsection 3. The Wayne County Trial Court's decision denying summary disposition to auto owners was affirmed. The Washtenaw County Trial Court's ruling granting summary disposition as to auto owners was, of course, reversed. The court's disposition was affirmed in part, reversed in part, and remanded. Jurisdiction was not retained. And that includes the February 2026 edition of MAIPF Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.